The next case to come before the court is Kalvyn Stull et al., the Summa Health System et al. Are all parties here?
Yes, Your
Okay, each party will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I'll be keeping track of the time and trying to alert you when you move into that rebuttal time. The arguments are being recorded, so please stay behind the podium, introduce yourself, keep your voices up. You should not use the names of children or minors or victims, should that be relevant to your argument. You can refer to those folks by initials or generic terms. The judges have read your briefs and we're ready to proceed when you are, and I would just ask the appellant, would you like to reserve time?
Yes, Your Honor, 3 minutes, please.
Very well. You may start when you're ready.
All right, good morning. May it please the court, Emily Engelwitz on behalf of the appellants in this case, Summa Health System and related entities and physicians, whom I will refer to collectively simply as Summa. Your Honors, this appeal arises from the trial court's erroneous decision to strip Summa of continued representation by its chosen counsel, Attorney Brian Osterman, to defend itself in this highly complex medical malpractice lawsuit. Indeed, Summa had specifically chosen Attorney Osterman to be part of the trial team in this case due to his specialized expertise litigating traumatic brain injury cases. Ohio courts have held that even in civil cases, litigants have a substantial right to counsel of their choosing. And the trial court's decision to deny Attorney Osterman's reapplication for admission pro hoc vice in this case, following a minor administrative oversight regarding his renewal paperwork with the Ohio Supreme Court, is completely at odds with that substantial right, causes severe prejudice to Summa, and constitutes an abuse of discretion. To understand why this decision is an abuse of discretion, the court need look no further than the trial court's stated reasoning and its decision. None of the trial court's stated reasons for the denial are supported by the record. For example, the court's concerns over discovery delays, disruptions, and other delays are simply unfounded because Attorney Osterman's admission and participation in the case never caused any delay in the proceedings. The only delay in the proceedings actually was the separate interlocutory appeal from the trial court's decision on a peer review privilege issue. That appeal actually remains pending at this time, and it's before the Ohio Supreme Court. Importantly, when this issue occurred with Attorney Osterman's renewal paperwork, the case was at that time stayed. And so the trial court's concerns that somehow this was causing a delay when essentially the case was dormant at that point is just not supported by the record.
So Summa has 3 other lawyers. Did Summa place anything on the record that this particular attorney was so specialized that like what you just said about the brain injury attorney? Is there something on the record that indicates that they couldn't find a lawyer anywhere else in Ohio, or that he is so special that if they didn't have them, they would be prejudiced, he would be prejudiced?
Well, I think that is, thank you, I think that's inherent from the record. I know there are, it's within the record that he does have this specialized knowledge and experience. He was brought on along with a partner at his firm to partner with our firm as local counsel as a team to try this case. And so, given Summa's strategic decision to proceed with multiple firms in this matter, particularly considering that this involves such a complex issue and there are other issues involving the fact that there was an accident before this case and going into expert discovery and all of that, it's important that Summa have the trial team that it assembled, and if anything, having it would cause delay in the proceedings for Summa to have to regroup and develop that team anew without Attorney Osterman, who they consider to be an important and substantial part of the team. Looking again to some of the other reasons the trial court gave in its decision, it looks at the integrity of the proceedings and it's concerned about that. That's simply unfounded. The record demonstrates that as soon as Attorney Osterman learned of the issue, he promptly notified the Ohio Supreme Court. The court accepted his reinstatement and promptly issued the renewal paperwork for 2023. Attorney Osterman had been admitted in this case for several years and had never, this had never been an issue before. He timely filed his 2020 renewal registration, 2021. Again, this was simply just a very minor oversight, and the trial court's essentially its decision to sanction Summa for this really minor issue is just at odds with Ohio's public policy that, you know, counsel is entitled to, that parties are entitled to counsel of their choosing. You know, the court also noted that this case involves, you know, quote, it's an extremely serious case involving a traumatic brain injury. Yeah, and we would agree that it certainly does, but if anything, that supports Summa's choice of counsel here. It doesn't support the trial court's decision to exclude Attorney Osterman from this case.
Remind me, if, when he was reinstated, was that retroactive?
It was, so he received a registration paperwork for 2023. So I believe that was for the year going forward, so.
And he was, he did not file his paperwork for 2023, so he would have been okay till 2022.
The end of 2022, right. I believe it was due, you know, in
I know the
January.
Supreme Court, I think it was February 6th, that they sent out the actual paperwork to say.
Correct. But I think the record shows that Attorney Osterman didn't receive it until the 23rd. You know, the court issued, or the clerk issued a notification on the docket just one day later. And then, you know, Attorney Osterman took very prompt steps to rectify the situation and refiled his pro hoc motion. It did indicate that, you know, the reason for this lapse was an administrative oversight. You know, despite this, the trial court denied his continued participation in the case. You know, we'll note also that from a public policy standpoint, if this court were to affirm the trial court's decision in this case, it would really set a troubling precedent. You know, would act as a barrier for litigants to obtain and retain counsel of their choosing. You know, any out-of-state attorney admitted pro hoc vice would be at risk for exclusion if this court were to affirm the trial court's decision. They'd be at risk for exclusion for any minor transgression. You know, this is at odds with Ohio's established public policy.
Wouldn't you think this case is distinguishable from just not allowing an out-of-state lawyer because there's multiple lawyers involved, and because there's nothing, sounds like there's not much on the record about the special need of this particular lawyer?
I think just based on the fact that there was this team assembled, and I think that's, like I said, that's inherent from the record, I don't think that would make it distinguishable. In fact, this is really a unique fact pattern, I think, simply because these aren't really challenged in this way, particularly when it's such a minor issue. And there really isn't a lot of case law from this court dealing with pro hoc vice. And so if this were to be, you know, the seminal case that's out there, it really would act as a substantial barrier for litigants to have counsel of their choosing. And so I think, you know, if the court affirms, that would be problematic in that way. You know, both sides discussed the case law in great detail. I don't think there's any case that's specifically on point to this issue. I wanted to address Appleby's point regarding, you know, how there are these two separate lines of case law regarding revocations versus initial applications for pro hoc vice. And our position is that this is essentially, it acted as a revocation. And so the court should look to those, it can and it should look to those cases. And in those cases, really, there has to be some sort of egregious misconduct in order to revoke that status. That simply didn't occur here by any stretch of the imagination. So, and even looking at some of the cases involving initial pro hoc vice motions, you know, the Martinez case, for example, the courts really looked to what was the trial court's stated reasoning, and was that valid? And, you know, here the court really didn't go through the list of factors. You know, it gave its reasoning, and, you know, as I've gone through, you know, it's just not valid from the record and constitutes an abuse of discretion for that reason. Again, the concerns with discovery delays, the only discovery delay was this other interlocutory appeal that was pending. You know, and again, the impact on the integrity of the proceedings, also just unfounded. And, you know, again, I can't emphasize enough that, like, this case will set this precedent for this district. And I think the court needs to determine whether it wants to be more permissive or more restrictive when it comes to these types of cases. And so,
What do you say about the admission pro hoc VJ as a privilege? And so when does the privilege become an obligation?
I believe it certainly, there's obviously case law that states it's a privilege. I think that in this case, because Attorney Osterman was already participating in this case, he was already representing Summa, and he had already, the court had already permitted him that privilege. Here, again, it really acts as a revocation, and I think that the court, should err on the side of permitting him to continue, simply because there just was not the egregious misconduct that's required in order to strip Summa of that essential part of their trial team going forward.
Well, that's one of the reasons I was asking you about, was he automatically reinstated retroactively? Because the revocation happened, didn't it, whenever he didn't comply with the Supreme Court standards requirements. And the court was notified that his ability to practice law in Ohio was revoked by the Ohio Supreme Court.
Correct, Your Honor. Technically, the Ohio Supreme Court issues a letter notifying the court of his exclusion, but it also sets forth the remedies under the rules for the government of the bar of what Attorney Osterman needed to do to be reinstated. It was really a simple matter of filing a reinstatement application, paying the renewal paperwork, and just submitting the required paperwork. In the meantime, the trial court, though, had taken the additional step of issuing an order that excluded him from further participation before he could, avail himself of these options and these remedies in order to reinstate, his pro hoc VJ status with the Ohio Supreme Court. And that's what led to him having to file a separate second motion for pro hoc VJ admission. For all of these reasons, again, we believe this constitutes an abuse of discretion on the part of the trial court, and we would ask the court to reverse the decision and remand for further proceedings. If there are no additional questions, I would save the rest of my time for rebuttal. Thank you.
Very well, you will have 3 minutes and 42 seconds for your rebuttal.
Thank you, Your Honor.
Thank you.
May it please the court, my name is Kristen Moore. I represent the appellee in this case, Kalvyn Stull, a young man who was left permanently in a semi-vegetative state after Summa allowed a first-year resident to attempt to unsuccessfully intubate him during an emergency situation. To adopt the result advanced by the appellant in this case would eviscerate the trial court's discretion to control and manage its proceedings in the face of out-of-state counsel who refuses to follow the rules. And a lot of what is missing in the analysis of the trial court's consideration is the concerns the trial court had about allowing this pro hoc counsel to participate in the proceedings in the first instance. He didn't seek to participate in this case until after 16 months of litigation. And the trial court was very reluctant to allow him to participate based on all of the factors that the case law sets forth, and did so only in a very limited capacity. The trial court's order allowing his participation said that an Ohio attorney would have to be present for all official proceedings, all hearings, all depositions. An Ohio attorney would have to sign all of the pleadings. The court would tolerate no impact whatsoever on scheduling. The trial court was reserving its right to address that counsel's participation during the trial at the final pretrial. These were all very unusual limitations that demonstrate the concerns the trial court had before the rules were ever even violated. And the trial court said in that order and underlined it. The court may revisit provisions in this order should it find that it's causing disruption in this case. That happened in February. 2.5 months later, the appeal to this court was instituted, and the pro hoc counsel had very, very, very limited involvement in the case. It's been stayed since then. The next thing the court knows, this attorney is excluded because he has failed to follow the rules.
In all fairness, though, it's still stayed because the Supreme Court accepted the case.
Certainly, yes.
So that's nothing to do with the attorney.
No, but it demonstrates that he has had limited involvement. It's not as if he has been actively participating in this case for years, such that he has become so entrenched as part of the trial team that that's a substantial consideration.
But also, just because someone has stayed, doesn't mean that attorney is not behind the scenes doing things.
That is true.
You know, so we really don't know at this point how active a role he's had.
Yes, the appeal does, what we do know from the record is that the appeal deals with an issue of statutory interpretation of the peer review privilege, which is very Ohio-specific analysis, as opposed to something that might pertain to his purported expertise with traumatic brain injuries. But you're right, there is nothing specific in the record as it relates to that.
I'm very familiar with it, yeah.
I'm well aware. And so the trial court then is confronted with this situation. And whatever this attorney may have been doing behind the scenes with the Supreme Court, it's several weeks before the attorney files the motion seeking to be readmitted in the trial court. And when he does so, he just footnotes this as if it is of no consequence whatsoever. And the trial court was obviously frustrated by the fact that this counsel had been warned that they were not going to tolerate disruption, that the rules were not followed, that the trial court was not immediately contacted, and that there was no legitimate expectation or ownership of responsibility over this failure. You know, it's just one tiny footnote, and everything that the appellant has in the record that they're trying to present to you is when they attempted to get their second bite and even third bite at the apple, building up this record after the trial court had already made its decision. If the attorney had taken this matter seriously when they first approached the court and had offered that kind of robust explanation, and perhaps the result would have been different. But the trial court warned them. I am concerned. This case has been going on for a long time. I am taking this matter seriously. And that concern was disregarded. And as a trial court, when you warn someone there will be consequences if you do not listen to me, and then you don't carry out that warning, it affects your ability to proceed not only in that case, but in other cases that other counsel have before you. So I
understand your argument about the court's rationale, but how has this prejudiced the appellees?
Yes, I think that the court's concern mirrors the appellee's concern, which is the court doesn't say, look, what happened in February delayed my proceedings. The court says, I am worried about the risk of future delay. And we all know in law and in life, when we add too many cooks in the kitchen, it tends to have the effect of slowing down proceedings, not speeding them up. So I think that concern was certainly on the minds of the plaintiffs who are, you know, this case has been pending for 4 years now, and they very much need this relief to provide the superior care that this young man needs for this life-altering consequence. And to have a counsel that has now demonstrated that they're not willing to take seriously what the Ohio-specific requirements are on them is enough reason for the court to say, I had these concerns, I expressed these concerns, and you have proven me right. You aren't taking this seriously. The trial court takes this case very seriously. The docket demonstrates the exceptional case management that has happened in this case. And if you contrast the trial court's involvement, 16 months before this pro hoc attorney got involved, the trial court had already had its normal case management conference. It had had, by my count, 6 status conferences. It had had an in-person hearing. It had addressed 9 separate discovery disputes. So it wasn't just that the trial court is upset about this interlocutory appeal. There had been 9 discovery disputes in that case before this attorney ever got involved. The trial court's taken it seriously, and it does not feel that this pro hoc counsel is taking it seriously.
But nonetheless, the trial court did allow his to begin with.
Yes.
Even knowing all those past delays and all the pre-trials and all the discovery disputes.
Certainly, and he had not been involved up until that point. But the trial court did allow it in limited parameters and with the caution that it would reconsider.
And the limited parameters were never appealed to this court. So he already was in a situation where he wasn't appearing at proceedings independently, he wasn't signing anything, and his ability to even participate in trial was not guaranteed under the trial court's prior order. That's how concerned the trial court was about this.
I have a question. Is there anything in the record about him being the lawyer preparing to try the case, be the attorney if there's a trial? Because many of these pro hoc vice attorneys come to try the matter. I'm asking because we're talking about the judge excluding him based on discovery, delay potential here, but if he's not going to really be involved in the paperwork, is that an arbitrary reason?
Well, I think that the court's, what the record said was he had petitioned and had argued he had this experience. So when the very first pro hoc
So
was,
there's something in the when he came onto the case, there's something that explains his role.
yes, that is true. But even with that, the court did not say they were necessarily willing to allow him to participate in the trial. So that balancing of the factors didn't weigh in favor of, oh yeah, he's going to be the guy that's gonna cross X, Y, and Z expert. You know, that wasn't something that existed with the limitations the trial court had initially imposed. I do wanna speak to the public policy issue that's been raised. I really disagree with the result that the appellant is proposing. I think that if this court were to reverse the trial court, the rule that it would be promoting is that out-of-state counsel are free to disregard their re-registration requirements, that the trial court has no discretion to do anything about it, and that even the most cursory footnote example of, you know, written in the passive voice, taking no responsibility whatsoever, is enough to overcome that process. I think it would result in an administrative nightmare both for the Supreme Court, who has to deal with that first administrative step, and then with the trial court, which is where the discretion lies. It is a two-step process. Just because the Supreme Court says, yes, you know, they have administrative people saying, you filled out this, this, and this, that's fine. The second step is the trial court, and the trial court has the discretion. And they're supposed to look at all of these factors. And the factors include that they have several highly competent counsel who have represented them for years and in many cases, and this lawyer had never represented Summa before. There was no prior relationship. So in addition to the 16-month delay before they decided his involvement was necessary, there was also no prior relationship there with Summa.
Counsel, would you agree that when the Supreme Court did in fact reinstate his status, that was operative as if it had never been revoked?
I would say that the Supreme Court reinstated him in that he was in good standing, but even their letter noted that he had this case pending and that was why he was receiving it. To apply again to the trial court is that second step. And to the point of whether this is a revocation versus the trial court considering it anew, I absolutely disagree that it was a revocation. His license lapsed at his own hand, and to apply again required a different set of circumstances. The Martinez case that appellant cite actually is instructive on that point. The appellant in that case tried to make the exact same argument. That was the one where the pro hoc had handled the whole first filing, hundreds of hours, tons of depositions, and then tried to file a new refiled case, and the trial court excluded him. He kind of got caught up in what seemed like a frustration with a lot of out-of-state attorneys. And they tried to argue that the trial court's decision there was essentially a revocation. And the appellate court said, no, it's not a revocation, it's a reconsideration. We think the trial court shouldn't have done what they did. We think that he got caught up with this frustration with these other out-of-state lawyers who were sanctioned, and he was not. So they reached a different result, but the finding was, it's not a revocation. We're considering it again anew. And that was the situation the trial court was in here. And having previously cautioned counsel they weren't going to tolerate any more delay, that was the result that the court reached. We don't believe there's
There's
any.
probably case law too that if you forget to do your paperwork as an Ohio lawyer and your license gets suspended, that you can't practice in this court, and that would be a reason for you to be removed as a Ohio lawyer, I'm guessing.
Yes, it's certainly true that there are always tons of consequences for failing to comply with deadlines and failing to be attentive to legal matters in cases like this and in many, many, many other instances. In this case, we don't think the trial court used their discretion. We think the trial court weighed the various considerations carefully. The trial court articulated what its concerns were, and that to reverse the trial court would take away its discretion to control the proceedings and would establish a precedent that allows people to be inattentive to legal matters throughout the state of Ohio. And for that reason, we would respectfully request that the trial court's decision be affirmed.
Very well. Counsel, you have 3 minutes, 42 seconds.
Thank you, Your Honor. Just wanted to address a couple of points. First of all, counsel for appellees, discussed the trial court's case management and its concerns over prior discovery delays before Attorney Osterman even became involved. Respectfully, that just has nothing to do, that can't be attributed to Attorney Osterman at all. He wasn't even involved in the case. And any restrictions based on those prior discovery issues, would be arbitrary, trying to restrict him from the case based on things that happened before he was even participating. Similarly, the concern appellee's counsel raises over risk of future delays, that's purely speculative at this point. Attorney Osterman had complied with the rules previously. This was just a one-off, minor issue. And so that wouldn't support the trial court's decision in this case either. I also wanted to...
Well, counsel, he really, practically hadn't had a lot of involvement with the court proceedings, at least, because he was only there for like 3 months before it went, before it stayed.
Yes, Your Honor, that timing is correct. However, given the complexity of this case and where they were at in the proceedings, again, as I believe Your Honor mentioned, that doesn't mean that there was nothing happening and he wasn't participating behind the scenes at all. The case at that point had undergone a lot of fact discovery, expert discovery was going to be ongoing, and that particularly is something that someone with an attorney with that specialized knowledge would be a part of. So even though the case was stayed at that point, that doesn't mean that at that point Attorney Osterman wasn't an integral part of this trial team. I emphasize that again, that this was a team chosen by Summa and not just particularly one attorney. And additionally, I know my opponent mentioned, the initial order of the trial court and how there were these restrictions. And I just wanted to address that briefly. I think, it's unusual for a pro hoc vice motion to be so hotly litigated in a way, and I think that the trial court's restrictions in a lot of ways mirrored what are already the rules with respect to pro hoc counsel. There does have to be local counsel associated with it, and I think that her cautioning in that order was a result of the fact that it was so hotly litigated at that point. And again, I think it's inconsistent, as a final point, I think it's inconsistent that appellees are consistently saying that, well, Attorney Osterman isn't necessary, Summa has competent local counsel, but at the same time are fighting his continued participation and the participation of his firm from the beginning so hotly. That just, if anything, demonstrates why he is needed for this litigation, and he does add value to Summa's arguments and to their representation in this case. So with that, are there any further questions?
Any further questions?
Thank you.
Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The court reports will